to Serve TV is live. I thought I'm going to catch you one of these days with the short intro, but I guess I didn't catch you today.
No, you can
catch
try.
you like half your blouse putting it on and your hair messed up, but as we go from
like,
we have that 37-second intro to a 7-second. It could be.
You did catch me. You know why?
Did I catch you?
Because I didn't put my sound off on my iPad, which I keep here.
That's
so
mine.
that's a catch. That's sort of a catch.
Michael Bryant here, Linda Kenney Baden. How are you? Good weekend?
Yeah, well, busy, but good. Very, very. Right. Every day you get up in the world, I think is good these days because I was as I was riding around hearing about a shooting at a wedding party. A mass shooting at a wedding party in a country club. I'm thinking, ooh, no place is safe. Keep your eyes and your ears and look out all the time. But
and
that's
Jets
the
got
world
so close, so close.
Oh, the Jets! They had a
frustrating game.
You're wearing green for my Jets because my Jets almost won it, but at 1 minute and 34 seconds, when they went ahead with that amazing block punt run back for a touchdown, I knew there was too much time for Baker Mayfield. It was like it's kind of like Tom Brady when he's he wins all these games at the end.
I would
agree.
But then I think I had a worse beat than you. I had a worse beat than you. Worse beat.
Play.
The guy, his name is Cardi. I call him Cardi B because he's usually pretty good. He missed. He had 2 blocked. People think that's the kicker's fault. It's not. It's the front line's fault for not taking out the same guys that blocked the punt. 98 and 90. Davis, I think his name is number 90, who did it the second time and kept the Eagles in the victory column. Anyway, enough of that.
Michael, are you on Starlink? Because you are breaking up big time.
Curious.
Just so you know, you're breaking up big time. Anyhow, so yes, I know. So we do have a rip and read. Are you controlling rip and read?
I can give you that. Hold on. Let me give you that. Let me find that and give that to you. Okay, here we go.
Okay, the first one's actually very sad. It's from the New York Post. This is actually a picture from the Facebook page. Tiger handler and Joe Exotic associate fatally mauled at Oklahoma Preserve, and that's Ryan Easley. He died in a tiger attack, an accident at Growler Pines Tiger Preserve in Hugo. It just, you have to always remember that these animals are wild animals, and no matter how much you think they're trained, look at the 2 magicians in Las Vegas, the one magician who was mauled by the tiger. They thought there was their family member would go in the house with them.
Sure. Siegfried and Roy. Yeah.
Siegfried and Roy. That was the name. And I remember seeing them in Las Vegas, but brutal. So, we express our condolences to his family and remembering for all the good work he did to try to preserve tigers that, couldn't go anywhere else, couldn't be let out in the wild. And the second rip and read, and I'll remove that from the stage right now. The second rip and read is actually something that leads us into our very serious case today, but I figured we'd talk about it as a rip and read because I want to have our friend Arthur Idala on because he posted that on Friday we kicked off CNN Newsnight with Abby D. Phillip, and I love Abby D. Phillip and I love Arthur, with a special Fall Fridays edition in collaboration with the Food Network. And I thought that maybe that would let us into something like with Comedy Central, that we should be comedians, that Arthur, you're in collaboration with the Food Network talking about criminal cases and all sorts of things. So Arthur, we're going to call you. Listen, put Arthur on the list. Ask him to come on tomorrow.
That's right.
Whatever, even if he wants to take something with us.
Arthur, who's been on a few times. Arthur, come back to the future. CNN is dead and gone. It's the past. It's deep sixth. So I'm not surprised they're trying anything and everything to get viewers because they got none. But anyway,
so
what else you got? Is that it? You got it?
That's it. I just thought we'd keep the rip and read short because we have so much to talk about. I know you're on the road because you were in court all day. But today was a little case, the Karen Reed civil hearing, and we, as we put it on our Justice Serve TV, let the pretrial wars begin. And so they did in Plymouth, Massachusetts, a place near and dear to my heart, not because witches were burned at the stake, but because once I had a summer house up in Plymouth, Massachusetts.
Were you near the Rock? Were you near the Rock there?
But, no, actually, you know how big the Rock is?
Oh, I've been there. It's an embarrassment.
It's an embarrassment. The Rock entering my driveway here is bigger. It's like
but it's there. And it's kind of weird how it's nestled up against the seawall and there's a little barrier around it. It's very, if you have some illusion and some sort of vision of what it's like, don't go see the real one.
Yeah, I always thought, right? Didn't you always think it was like a big
of
rock?
course.
Yeah.
And where is it? It's the Plymouth Pebble. What is that?
Yeah. The Plymouth Pebble. My son always said that Greenland was the first major land fraud, because you call it Greenland, but it should have been Iceland, and Iceland should have been Greenland and all.
Yeah.
So the Plymouth Rock is like, come see us and advertise. Come see Plymouth Rock, where everybody landed and the boats, and then you go see it, and it's like, where's the magnifying glass?
Yeah, it's brutal. It's very disappointing. Anyway, so much more interesting what was going on there today. I have one overriding comment, and first of all, I did get to re-listen to it as I was coming from court to my location here. My biggest takeaway is my only goal is to be alive if this ever goes to trial, because it's way down the road if it ever goes to trial. And you could hear the judge at the end, Judge, what's his name?
Daniel O'Shea. The players are Judge Daniel O'Shea, the plaintiff's attorney, Damon Seligson. Alan Jackson was there, but he didn't say anything. And the defendant's attorney is Karen Reed, and the plaintiff's attorney, Mark Dillon. So we can say plaintiff's attorney, defendant's attorney, and the judge, now that we know their names.
Yes, and I think there were 6 defense attorneys, as I recall, and there are only 3 defendants, so do the math on that. Anyway, you could tell the judge from the very beginning, and reinforced at the end of the hearing, which was barely more than an hour, you guys got to settle this piece of crap. You got to settle this horrible case. You're not going to get anything that feels like justice if you go to trial, but I'll be happy to go. We can go as early as next spring if you want. We can just do that. There's not a chance in hell it's going to happen. So let's talk about the first biggest potential issue, and that is defense.
But he's efficient. But he is efficient. It started at 1:57, by the way, 3 minutes before, and it ended at 3:01.
Yeah. So and a lot of that was just BS you didn't need. And we're going to talk about that from the various sides. But from the judge's perspective, he knows this. He's just hoping to get this off his plate. He's apparently been moved to another department anyway, but he's retaining jurisdiction over this.
No. How it goes in Massachusetts, he's assigned to the Plymouth County, but Plymouth County has 4 different. They rotate, like in the old days of West. Right. So I think I sent you. One's in Wareham, and used to be in Fall River. Fall River. One's in Wareham, one's in Brockton. I forget where the third one is, and the main one is in Plymouth. So he then rotates next to Brockton, which is further away.
So he's been moved, but he's still going to come back to Plymouth for this case.
Yeah, for this case. And people are reporting it differently. They're saying, they have to go further away. No, he specifically said, if you listen to the end, as you should if you were paying attention to the end of the Rams game and the Eagles game, along with the Jets game, and
never over till it's over.
Tampa Bay, it's never over till it's over. He said that he is being moved next month, but he will be back, and everyone can come to Plymouth, and he will move to Plymouth because this is specially assigned case to Plymouth. Okay.
And he was even pushing to do it by Zoom if anybody wanted. No, defense said, no, we'll be here in person. Thank you very much.
And then the plaintiffs everyone wanted to come in person. They wanted to come back because you know why? This is a media thing. This is how you get to push your side and your complaints out there. I know this very well. If you can do it in person, of course you want to do it in person.
Yeah. So anyway, they will. But let's talk about what happened today with the first big bombshell of sorts. I hate to use that term, but I think this one qualifies. When defense counsel suggests they're going to bring in about 10 more defendants.
Yes.
And how to do that in the context of this existing case. The defendants have not even answered. And just for those who may have missed this day of civil procedure, you have a complaint that's filed. Usually 30 days later, you have to have an answer. That is the defendant responding to the complaint. You can get it delayed. We know in this case, virtually everything was told, meaning stopped, while the criminal case was playing out. And as soon as that ended, they released that tolling, and the clock starts ticking again. That has to do with everything from discovery to simple things like the answer. So there hasn't even been an answer from any of the defendants in this case, which makes it unusual to bring a motion to dismiss before you even file your responsive pleading in the form of an answer, because technically you're not even before the court yet until you put your answer in. So talk about this parade of defendants or cross defendants that
let's talk about it. And while we talk about it, let's put into the screenshot here the fact that we have a complaint. Let's just put the cover page of the complaint, and that's how things get started. Misty, I think you've got that right. We'll just add it there, and that's how things get started in a civil case, right? you file a complaint, and here the complaint that was filed is Paul O'Keefe as personal representative of the estate of John Joseph O'Keefe. And I'm doing this for a reason, Michael, by Paul O'Keefe individually, and John O'Keefe, Margaret O'Keefe, and Margaret O'Keefe as grandparent guardian of Kaylee Furbish, because she played a major role in the argument. And then versus all of the different LLCs, the Waterfall Bar and Grill, the C&C Hospitality, doing business as C.F. McCarthy's, and Karen Reed defendants. Okay, so this is what gets filed. This is what you were talking about. And it was filed on August 6, 2024, right? And here's your generic plaintiffs. Now, the plaintiffs filed this complaint. The defendants, as Michael Bryant says, have to answer. And of course, Karen Reed had a Fifth Amendment right, and it was her right to answer, which she does have a right, was delayed to the ending of the criminal trial. Now that Fifth Amendment right may or may not still exist, given what Special Counsel Cosgrove is doing. So that's interesting. That's something else we could talk about at another time. And all. So yes. So then what happens is you can file a motion to dismiss a complaint on its face before any answer is filed. Okay, that's usually done in federal court. But even with that, even whether there's an answer filed or not answer filed, the judge has to take the pleadings that were on their face at face value. He has to assume everything in there basically is truthful and is true, and that the plaintiffs can prove their case unless it shows that there's some type of ridiculous charge being made. Okay, so that's kind of where we were. So the defense came in and said, we haven't answered, but we wanted to advise the court. And we're gonna play the clips for you, by the way. We want to advise the court that we want to add 10 different plaintiffs in, and so we thought we'd give
10 different defendants.
10 different defendants in. Well, it's actually our defendants. Okay, it's defendants. It's going to be a third-party complaint, so you're bringing new defendants in, right?
But if you're a defendant, bringing them in as a cross defendant, they're not going to be on the same side as the plaintiffs. Let's put it that way.
No, they're not going to be on the same side of the plaintiffs. But well, they may be on the same side of the plaintiffs. But he wanted the court's permission to bring the motion in. All right. So I mean, there's all sorts of civil procedure that is going on here. And then that ended up being getting a little rancor of the plaintiff's attorney and a little rancor later on of the judge. But this is where we stand right now. And the judge didn't stop it. As I'm giving you the end result, the judge didn't stop it. But boy, was there some stuff going on and some press releases going on in terms of what was happening in court from the plaintiffs, okay? Especially when it came to the pleading of Kaylee Furbish, who was the niece of John O'Keefe, who he was taking care of and had guardianship on, right? And because people were asking, I saw comments today as I was listening, who's Kaylee Furbish? Who's Kaylee Furbish? People didn't even know. Well, you know, everyone else knew who Kaylee Furbish is in that courtroom. I can tell you that and all. So was that the question you asked me, Michael? I
don't remember now. Were you going to play that clip? Were you going to play a clip of some of this?
I want to first play the clip of the defense attorney and his Damon Seligson, who we can listen to all day. He's got such a beautiful lilt to his voice. It's not a New Jersey accent, that's for sure. At least New Jersey in my state of the United States of America. Why don't we listen to him tell the judge, Missy, can we get to that point? Tell the judge exactly what he wanted to do.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reid's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reid in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reid, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reid was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reid's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay, so let's stop it right there. They'd like to brief it.
Right.
Yikes. And we're going to have somebody, Michael DelSignore is in the waiting room. He'll explain some of this later on to us in the Massachusetts law. And I just want to tell everybody who's already given a lot of comments here that we're going to be doing the second episode on this tomorrow night, going more in depth on this. But tonight we want to just show you what happened and about what's happening there. And Joey Kane, by the way, is all of your awesome sauce, member for 1 month. Thank you. And I just want to point at Joey and Jenna Platypus. I love hearing your points of view, Linda and Michael. Thank you so much. And hopefully you'll love hearing over 2 hours. And Joey Kane gifted 1 Justice Served TV membership. And I saw that it's already been given. And another one I saw that's already been given. And you know what? You have to hit that subscribe button to get one of those. Unless you're subscribed, they're randomly assigned. We have nothing to do with it. And Joey and Jenna Platypus gifted 1 Justice Served TV membership.
Hey, can I follow up on my YouTube gripe? Because this is a follow-up. So it's very short, very quick. I was talking about YouTube last week and how we seem to have been throttled. And we were like,
because we were growing too fast.
So we get 500 new subs over the weekend. So YouTube, just do the right thing here. Come on. Just quit stepping on the gas and putting on the brakes. Come on. Okay, go ahead.
No, but thank you very much, and it's because of people whose generosity we have here. Madeira Beach passed. Oh my God, Madeira Beach! I can't almost read it. 10 Justice Serve TV memberships. I know the other ones were already randomly. Madeira Beach, thank you so very much.
Is that because of my new shirt? Is that it? And there's a new shirt. Yeah.
It's because she's wonderful and she's our hospice nurse and she understands trauma, tragedy, and everything that's happened. And one of our great viewers on this channel, by the way. And if I've offended by anyone, by the way, on this channel in the past, please, you know that I'm very passionate about what I do. I'm passionate about the law, and bear with me, and you can call me out if I do it. There's no problem. I won't take offense. But thank you very much. So with that, that was like yikes. So and there was some wrangling that then went on about the defense was going to say these are affirmative defenses, and the plaintiff and defense counsel Karen Reed again said no, they're not the affirmative defenses. These are third-party complaints against different parties who haven't been there, and they're federal. And the defense was saying, well, you shouldn't have you can't bring a federal claim in a state case. Absolutely wrong. Okay. Yeah. Of course you can. A 1983 case, and that's what they said. Most of them will be 1983 cases. Usually, the other side removes them to federal court.
That's exactly right. And if I'm the plaintiff, that's what I'm envisioning. Go ahead, bring those. Let's see how it goes. I don't think anybody wants to be in the federal system with this case.
Well, you know what? That may be the issue, because then you're really, you're talking about a leash. Oof. There
is a schedule, and we are going to stick to it. None of this, like as it stands right now, best case scenario, unless somebody says, "Oh, Judge, we'll take you up on that spring 2026 trial." That's not happening. It's set for spring of 2027. As it stands now, if you don't bring in any of these new people, so like I said, may I live long enough to see this thing.
This is all about getting all sorts of stuff, which we'll talk more about. But today we just want to tell you what happened and what the law really is. And then we're going to bring in Michael DelSignore, who was our Massachusetts attorney who does this work, is going to join us here as we go and listen to. Hi, Michael.
Hi.
There we go.
Yeah, looking rested after your week on vacation. Well, now we're going to work you to the bone. Okay. This is, we heard the claims they want to bring in: Massachusetts State Police, negligent training and retention; Brian Tully, civil rights; Yuri Buchanan, civil rights; Proctor, civil rights; Brian Albert, civil rights and conspiracy; Nicole Albert, civil rights and conspiracy; Jennifer McCabe, civil rights and conspiracy; Brian Higgins, civil rights and conspiracy; and the town of Canton, negligent failure to secure the garage and the Sally port. So then there was things went by, and then the plaintiff's attorney had a right to speak, and he decided to make it a press release. And I thought, okay, and I think Michael will tell me, okay, some of his arguments seem pretty good, although you're going to talk about the cases he talked about. And then I'm going to warn you all. To me, he went off the rails when he decided to attack Dr. Turtleboy, Aidan Carney, as part of his claim here, which I thought, okay, you're doing okay with what you have, plaintiff Mark Diller, because it's a plaintiff's case. You only need 6 jurors. I assume it's 5 out of 6 in Massachusetts to get a verdict. It's not beyond a reasonable doubt. So you're doing okay. You're making your press statement. So why don't we listen to it? And then, Michael, you're going to tell us about the cases he cited.
Okay. All right. Great.
Let's listen.
The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard. The Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are 3 arguments that my brothers have put forward in this case. We oppose all 3 of them as follows. Number 1, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED
Stop it right
claims.
there for a second, Missy. Can we stop it right there? NID is a negligent infliction of emotional distress. You're going to hear the words NIED, and you're also going to hear the words IED for intentional infliction of emotion. IIED, intentional infliction of emotional distress. Some people on X Twitter today thought we were talking about bombs being dropped.
Yeah.
Explosives. So just so you know. So that's the shorthand for it. Okay, let's continue.
By creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument.
Hey, can we
JJ's
pause it
parents
right
are the
there,
next of
Missy?
kin.
Can we? I want to get Michael to weigh in on this because I'm going crazy listening to this guy drone on. Let's talk, Michael, about
we can finish him. By the way, we can finish him tomorrow night.
Yeah.
Let's talk when we do the more in depth again. But yeah, go ahead, Michael.
So Michael, what he's suggesting is in his argument against the defense motion to dismiss, and remember, it's a motion to dismiss the emotional distress counts only. It's not to dismiss the whole case. I've seen all kinds of misreported information suggesting that.
Right.
So,
No.
and again, it has to mean that on the
113.
face of the complaint, there is nothing to state a cause of action. Okay. I don't know. I want your opinion first, Michael, if you think it's going to be denied, as I think it is. And what he's arguing here to separate himself from what the defense says is the reason the motion should be granted.
I think he's correct. The emotional distress common law claim is not precluded by the wrongful death statute. The case law is clear on it. So if there's a recovery for wrongful death, that money goes to the estate. The emotional distress claims are all individual claims, so they can both coexist. Presumably the estate could have, could owe a creditor money. So maybe they get money and they have to pay it. Maybe it doesn't even go to the family, but the claims are individual. So they're two separate ways to recover money for this. So I think he's absolutely correct that they can still pursue the claim despite the wrongful death statute.
Is that the Camino case that they were talking about? I think I texted you Camino, but Camino case, and there was a Cohen case too.
Correct. I found that that was in both cases that the wrongful. Some other lawyers have made the argument that the wrongful death statute preempts a common law emotional distress, and the courts have rejected that.
Yeah, I think that was the weakest argument that they made. I mean, the better argument was that there was no true emotional distress. Again, I don't think it's going to be granted because at the pleading stage, no court wants to do that. There may be facts that develop or don't develop, suggesting they don't meet the requirements for either negligent infliction of emotional distress or intentional infliction of emotional distress. And you hear plaintiff's counsel trying to pepper that, with these fantastical stories that like he never saw the first trial. That he's already got it worked out. She hit him. She had this big plan. She started to conspire. Well, good luck proving that stuff. Do you think, Michael, this is going to come back in another form at some point? Summary judgment, something of that sort?
Sure. I think they could make a summary judgment. That'll be a higher standard. I think the real problem he's going to have is proving that there was a collision, as that was the main issue in the criminal trial. If he proves there's a collision, she knows, then I think his points are well taken that, well, if she lied about this, covered it up, of course, it's foreseeable that they're going to suffer emotional distress. I just don't know that he's going to get beyond that. There was an accident. They can prove that. The emotional distress claim really, it depends on proving that it's foreseeable that those individuals are going to be suffer severe emotional distress. I think this is a case where that part of it, if they prove negligence and that she caused the accident, emotional distress, they should be able to prove.
So I want everyone to understand that different states are different, okay? In my state, you have to see. I mean, if you're going to argue that an accident caused you emotional distress, you have to see you're the wife standing out, your husband gets hit by a third party, and you're watching it. Then you can claim independently severe emotional distress. Or in the federal court, if it's a police officer that's doing something, you have a right to claim a substantial a due process right. For damages independent of not procedural, but independent of any other claims in state court. So Massachusetts does it differently, though. So anything that may cause emotional distress related to an incident, including maybe lying about it, is actionable. Michael, is that what we're saying? Is that what they're saying here?
Well, because they're close family members, they knew about it within close proximity. They were there. I think their claims would be actionable. We don't use the zone. There's a lot of different variations of the rule. Are you in the zone of danger? Our court just says, is it foreseeable? Plus, they have to have physical manifestations of their emotional distress. So that's how our court limits who can make a claim. So if the way the lawyers outlined it, because the family knew about it right away, she brought them to the scene. I think that's a good emotional. She brings them to the scene. If their theory is right, which then she brought them to the scene knowing that they were going to be traumatized and she was lying. That's their theory. If they prove that she caused it, I think they got a good emotional distress with the close family members.
But that's a lot of butts. That's a lot of butts in there.
That's a lot.
Yeah, that's a lot of butts.
I think California is much closer to New Jersey than Massachusetts. Massachusetts, not surprisingly, since we know very well now the intimidation of witness statute means my feelings were hurt, so therefore I have a case. Massachusetts much more liberal about what they would consider an actionable case. But I think we could all agree that a negligent infliction of emotional distress case may have some potential. Intentional infliction of emotional distress is a whole different animal, Michael.
Right. Well, their theory is basically she did this intentionally because she brought them back knowing that she had struck them. So the two, I think, are going to merge together. I don't know that you get one without the other. Their claim really is that she did it. One, she committed the emotional distress when she drove drunk and killed him. And then two, when she lied about it and covered it up, that was the intentional. So I under their theory, again, if they prove the accident, which is going to be the major point, then their emotional distress claim, I think, is easier than proving the accident, because now at least they'll have presumably overcome all of the issues in the criminal trial if they're at that point.
Yeah, it sounds to me though like you can sue anything for anyone. We've gone away for the reason why we have statutes called wrongful death, and that's they allude to that. That would be your pain and suffering that the person who was killed suffered, right? That's our John O'Keefe's claims. And then we have the survivorship statute, right? And that's the survivors, what the survivors lost, which are different damages. New York State, by the way, New York State has tried to amend those statutes a number of times to give survivors more rights, and we don't do it in New York State. In New Jersey, you're limited. You don't have all these additional claims. So it really is interesting. Now, somebody points out, I'm putting this up, Judge O'Shea is the same judge that signed Aiden's search warrant. If he was involved in Aiden's case, is that a conflict of interest with his judge? I also tweeted about that this afternoon, or X'd about that, because he's also the same judge in my Aaron Hernandez. Well, it wasn't my case then. It was the first Aaron Hernandez case. I did the second one where he was found not guilty. But in the first one, he's the judge who signed the warrant of no bail for Aaron Hernandez. So he has a long history in Massachusetts, both doing civil and criminal, which may also surprise people that judges in Massachusetts get assigned to that. Michael.
He's a great judge. I've been in front of Judge O'Shea quite a bit. You're right. He did the arraignment for Aaron Hernandez, and he was involved in the initial stages before it went to Superior Court. But I think he's well respected by both sides. He's known to be fair. And I think he's going to give everybody a fair trial. He usually brings the evidence book to court with him. He knows the law. He'll study it. He'll make reasonably quick decisions. And I think he'll run this trial very well. So
well,
I think this.
he certainly ran today, and I see it in our chat. We're talking about the scene expandingly here. It's not talking about the scene of the accident, the scene of the hospital. There's different scenes here that these pleadings apply to. Okay, just so you all know. And then yes, they call the hospital scene. Yes, all these different things are scenes in the pleadings. It doesn't mean it's right, but that's what's called different scenes according to the pleadings here. Now, I'm not quite for that. I think it's ridiculous, but it is what it is right now. And so, Michael, explain to us the fact that this is just on the pleadings. There's been no discovery, no nothing. You have to take the pleadings as they are and assume they're correct.
Correct. It's very limited. It's basically saying that if everything the plaintiff says is true, does the law provide a remedy for it? So, the only way this would get denied is the motion allowed. There's the Cohen case basically was where the person was nowhere near the scene, learned of it through a third party. So there are ways that a motion to dismiss could get allowed if it was clear that there's no facts. But generally the judge would, as Michael Bryant said, deny the motion, let them do some discovery, then they'll refile it for summary judgment. The standard's a little higher. So I wouldn't expect Judge O'Shea to allow any of these motions at this stage.
Okay. Thank you for your clarity, Michael. Go ahead, Michael Bryant.
Yeah, let's talk about discovery, because that is where we're going now, at the very least. It's a long process. And, it starts with written questions generally, or requests for admissions on certain facts that one side or the other wants the other to admit. Then the very last thing, which everybody is, drooling over, are depositions. And they're always dead last for one easy reason. They're expensive. And nobody wants to expend that kind of money unless they know the case is moving toward either trial or some sort of resolution. Sometimes, I'm sorry, there are bees attacking me. Sometimes, the deposition is just to get settlement. You're not going to trial, but you want to use that tool. So how do you see that playing out? I think their final discovery deadline is, the end of 26.
August, at the end of August next year.
Yeah.
As far as written discovery, they can ask interrogatories, requests for admissions. If you're the plaintiff, I think you want to take Karen Reed's deposition and ask her questions. I don't know that you want to prep her with interrogatories. Where are you going? I think you want to ask her, hey, she called her dad at 4:30 in the morning. Why'd you call your dad? Why'd you call your father? Do you always call him 4:30? What were you doing? You can really get into a lot of specifics. Why did you say, I hit him? Why didn't you say, who killed my boyfriend? Why didn't you go into the house? So I think it's gonna be a fascinating deposition, just to see how she responds to all that. You really thought you didn't seem to think it was a conspiracy, and to see how she responds to that. I think those questions are going to be fascinating, how they prepare for the deposition. But I don't know that I would give her any sense of where I'm going with the deposition. Her interrogatories, the lawyers are going to help her answer. So I almost find those to be pointless in a case like this. When we already know all the facts, we've had 2 trials. There's really nothing they're going to put down in writing that's really going to help, I would say.
Okay, so I have one other question for you, because I don't think that in any way in hell the defendant's going to allow her deposition anytime soon, because you're going to have all these motions on whether we have the 10 new defendants and whether or not there's a federal case, and should this be stayed until they're added to the federal case and they're deposed. We're going to be in motion practice. You all know, it, and I know it, for a really long time. Is this, at some point, do the plaintiffs go away? Does the insurance carrier just say, here's my policy, I want out, Waterfall Bar, CF McCarthy's, I want out, I'm giving you my policies?
Well, I think CF McCarthy definitely has the most incentive to settle, because I think the over-serving claim seems pretty strong. The sentiment, the public, I think people want to do something for John O'Keefe. So I think the CF McCarthy certainly has an incentive to settle this case. Judge O'Shea at the end of the hearing tried to encourage everyone to settle it. Whether
good luck with that.
It doesn't seem like that could be. I think their only leverage to settle with Karen Reed is if she maybe doesn't want to go through a deposition. Maybe they can come to some resolution where they donate some money to a John O'Keefe Foundation where everyone kind of saves face. But I'd say it's unlikely. I think the trial will go forward, but maybe CF McCarthy's would potentially settle and remove themselves as defendants from the case.
Yeah, I know if I was representing them, if the insurance company had hired me as theirs did hire counsel, I'd be offering. I'm assuming they have policy limits of maybe $1 million. You know, it's an expensive kind of business to operate. Could be more than that. But I'd be suggesting just offer policy limits, get yourself out of this mess, and move along. Number one, you don't want to expose personal assets if you can avoid it, and you know, why drag your establishment through that mess? So.
All right, Michael, thank you very much for your knowledge tonight. We'll be calling on you again, and we appreciate you coming on the show. And we're going to talk more with Jason Grant, who was in the courtroom to see what the vibe was like. Thanks, Michael DelSignore. Appreciate it.
Thanks, Michael. Take care, man.
Okay. All right. So we're going to have Jason come on now, and we're going to play. We'll finish Mr. Diller's arguments tomorrow. All right. Why don't we have Jason come on? Why don't we listen to what the judge said? And Missy, can we show some of the screenshots for what the court looked like? Because I think Jason was in one of those screenshots. Can we show that?
Jason, you couldn't hide?
No, that's the judge, by the way. That's the judge.
I was right on the end seat.
Are you there? Can you see yourself, Jason?
Yep. I'm right there between Paul and Aaron. You can see behind Paul and Aaron.
Yep.
Okay. Yep.
Back there, yep, in the corner.
There you are. There you are.
Yeah, it was a big courtroom too. It was packed. The O'Keefes probably had like one row. The rest of the court was all Karen supporters.
Looked like a wedding. The plaintiffs run one side, the defense another.
Right.
Behind there, and also and look at that's the view that to the left is the waterfall and the bar lawyers are in the where the jury box was, just to get a hang of this. Everyone.
Yeah, there was so many lawyers. I think like the O'Keefe side had 2 lawyers. Karen's side had 8 lawyers, and there was 3 for the bars. It was like it was funny. They were announcing their name for Karen Reed. For Karen Reed. It was like
I love the woman. I love
funny.
the woman at the end who I didn't get her name. She said, "I'm for Karen." Okay,
yeah.
I thought right. That was a great way to bring up the rear, so to speak. Right,
Jason, did it feel like? I mean, I was just watching it. I wasn't there to get the vibe, and obviously it was predominantly Karen Reed supporters. But didn't it just seem like overkill at some point with all of these defense attorneys?
Yeah, yeah. I was like, it was just weird. I was like, yeah, I'm for Karen. Yeah, it was a lot. But Alan said he's like, she's not no more defense. She's going on the offense now. So they're not playing around.
Well, I'll tell you what, the lawyer, and we didn't play the clip. We're going to play it tomorrow night. But the lawyer, Mark Diller, when he started talking about how, and I have 6 pages of notes, and I was trying to keep up, how the Karen Reed choreographed Turtle Boy leaks, autopsy photos, and Turtle Boy, Dr. Aidan Carney said their time for grief expired and they are now fair game, and then blamed this on Karen Reed, blamed all this stuff. I mean, I just thought that's when he lost me. I said, this is outrageous. Yeah. This is ridiculous. This is ridiculous. And everybody should have known that the family was vulnerable at that point, and she had a misinformation campaign with Aidan Carney. And we can't wait to get Aidan on, because I know that he has been tweeting up a storm about this today. How did the courtroom react when that happened?
Oh yeah, they brought up, they kept bringing up Aidan's name and trying to tie him and Karen together, and then they kept saying how Karen knew she hit him and left and came back, and like I was like getting aggravated. I was trying to just not show any emotion and react in the courthouse, but I was getting mad in there, like listening to it and redundant. But
my first thought was, well, how come Aidan Carney's not a defendant in this case after you've just told us all these horrible things that he did? How come he's not a defendant? Exactly
right. Like if they're saying Karen and him are in cahoots, why is not he named and stuff? It's just like he was going on, and it was just like he lost me too when he was just going on about Aidan and this and stuff he was saying.
It was a press release. So this was his presser that he couldn't make.
Yeah, because it's a crap case, and this guy's got to do what he can with it, squeeze the insurance money, and
And
get
he may
away.
get it.
Yeah, they're hoping one of the bars might settle. They just want to get it over with.
Even with that, they may make a motion to the judge to put their policies in the court and leave. I mean, they don't say, here's your policy.
Right.
Yeah,
We're out of here.
it's called an interpleader. You just dump it on the court. You walk away, and you're totally out. And I would fully expect that, and I would recommend that. Jason, what was the interaction, if any, amongst all of these attorneys? Not necessarily all the defense attorneys together, but the what were there, 14, 15 attorneys total? Was there any interaction between plaintiff counsel and defense counsel?
No, not really. They came in, sat down, and I can't think of the lead, the attorney that was speaking. I can't think of his name, but he pretty much did all the talking and stuff, and then
David Seligson.
And
he didn't really respond to Mark Diller. All he said, and we'll play that tomorrow night, was, Your Honor, we rest on our pleadings. And he wasn't going to get into that fist fight there because they have a different case that they're trying to do.
And I appreciate that. Even the guy who represented not McCarthy, McCarthy's, I think it was. He decided to chime in, but he basically repeated everything that had already been said.
What he said, exactly.
Sometimes you can't shut attorneys up. That's just the bottom line. They're charging by the hour. They think they got to throw some words in there, but he added nothing to the mix.
Paul is a new member. Thank you very much, Paul.
And it was interesting to see how they said they're gonna who they're gonna go after, the state police, Brian Albert. They decided naming the names and stuff. It was
and that was part of the defense press release, Linda. That was their press release.
If they can add the other 10 other people into this case, it's going to be crazy. Having one big case. It should be, because it's so complicated, and it's just too hard to follow. If just get everyone in there and get one case and sort it out.
Well, why don't we listen to what the judge said at the end, which will give us a hint as to what he plans to do. His final ruling, and he called, by the way, what the defense was doing, a temporary wrench, not wench. Somebody I saw tweeted wrench, a tool. Why don't we listen? We're getting there. There we go. That's Damon Seligson. Okay?
Yeah.
All right.
With the procedural things that might be asked for at some point, that this case will have a very long tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately, in this case, is a very long and sort of complex process that litigation provides. And this is a civil case. It's not a criminal case. There are 8 parties, as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. And we literally have talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there's be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. And what you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-dispositional, post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench that's been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore it. We say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
God, I hope not. Hey, have I mentioned you could resolve this some other way? Have I mentioned that? Oh,
yeah.
God. Pressing for resolution.
Oh yeah, he kept saying it. Yeah, when he was saying that, so that made me think about the restaurants would probably just settle, get out of it, and he was like, "You could drag on for 20 years," and so I think the restaurant. I can't see Karen like settling. There's no accident.
For a minute,
well,
Jason.
You know what? Jason, when he was doing that, what was the attitude in the courtroom? And Michael Bryan, I have a question for you. I asked it before. Maybe we'll talk about it tomorrow night. Doesn't Karen Reed also have a 5th Amendment privilege still now with this whole Cosgrove investigation?
Yeah, she's still worried about Cosgrove trying to get her phones to tie her to charge her and Aiden together. So the 5th Amendment should still apply too for deposition.
Yeah, I mean, we're going to see how that plays out on both ends, and I would expect that the Cosgrove issue will be resolved before deposition ever needs to happen or not happen. But let me ask you this, Jason, because the alleged liability of the Waterfall Bar and McCarthy's are these dram shop laws, DRAM they call them, where basically you're responsible if you overserve somebody. We learned from the trial, both 1 and 2, that it's epidemic there. You're just getting overserved, cop or otherwise, and then you're just driving off. What's your experience?
Everyone was over. Everyone was drinking.
But what's your experience in seeing the community? Is that normal? Are these 2 bars unusual? What?
No, I guess pretty much the same. As long as if a bar can't tell it, unless you're like falling down drunk, they're not gonna give you a test every time you come up for a drink. So I don't see what they drank and what they served. Is anything unusual from this area of going out and having drinks at night at the bar and stuff. And
here's an important follow-up question, because we saw, during the videotape, counting of the actual drinks. There's a drink, and then there's a shot, and is the alcohol watered down? I mean, because there's a shot, then there's a shot. You know what I mean?
Yeah. It's definitely, 'cause it's a shot, but if I was drinking at my house at a cookout or something, and I was making a mixed drink, I might put a couple shots in there, and
well,
a few drinks, and you're fine.
The shot itself, is it watered? I mean, I know the drinks are watered. That's just the nature of the way they make them. But that assumes the shot is actually all liquor.
An actual shot, yeah. Depending on the bar, if you're a regular at the bar and you know them, they might give you a heavy pour. But they might just skimp on the pour too to save money and stuff, to make up for giving someone else the extra pour. But I didn't see nothing unusual with the bar with the when they were going over that part with the shots and stuff and all that.
Yeah, that's kind of
It's pretty
scary,
much
actually.
Yeah.
Yeah.
And then now too today, like Uber, so they don't. But you can assume you get an Uber home. A lot of people will take an Uber to the bar and stuff now these days, compared to back in the day. Everyone just drove drunk, pretty much.
Crazy. And this was just 2022, so it wasn't like back in the horse and buggy days.
Yeah.
And the cops are as scary as anybody else too. I mean,
those guys are drinking all day long from New York, coming back. How many different bars, and Karen's the only one charged with the DUI.
And she's completing her I guess her probation, which gosh, is it over yet? I mean, time is just flying.
I know. It was nice. Like, today, it felt like I was back in Dedham again, because we got to the courthouse early. Was out there with the regulars were there, and Mr. and Mr. O'Keefe came out. They were hanging out front of the courthouse with us, waiting for Karen to show up. And then it was almost like the old days. He's going to see Alan back again, and then Evan was there. Evan was the BC intern, but now he's working in California with Alan for Alan's office. I talked to him for a minute. That was cool. He's working with Alan now.
Such a bizarre shared experience that I'm sure there was some of that homecoming kind of feel to it.
Yeah, it's crazy. It's like a family reunion or something almost.
Yeah. Well, Jason, thank you for coming on and sharing what it was like in the courtroom. I know we're going to be seeing more of you as we continue to talk about this.
Yeah, my pleasure. Anytime.
Thank you, Jason.
Thanks,
You're welcome.
Jason. Take care,
guys.
And Michael Bryant, apparently, good God, I just want to tell somebody. I'm not going to post it because I'm not going to give the. We are a non-political channel, okay? We have certain views that have nothing to do with politics. I'm a flaming Democrat, as people know in this channel. Michael's a flaming reasonableness.
I'm a reasonableist. I'm the only one in the whole party, just me.
All right. So I don't know what you're talking about, unsocialized butterfly, but I'm not putting your chat up there. I'm not going to start to put up there because our views on the law have nothing to do with our politics. All right. I don't even know what the politics of any juror I've been in front of, and I don't care. Because I try my case and I represent my clients. And whether we like, and maybe this stems from my supporting Ashley Merchant tweet. Ashley Merchant supported a Democratic candidate. She supported Fani Willis, but that doesn't mean that when she gets in that courtroom, if she's hired by somebody else, she's not going to try to apply the law. All right. And if it stems from that, okay, I'll take it, because Ashley Willis is a goat. She's a friend of ours.
She's amazing.
And we ain't changing our views because we have one dislike about our politics.
Yeah, you'll have to share that with me, because I don't know what that is. Here's on a lighter note from Donnie Not Wahlberg. And by the way, I sent the mug, right? Wasn't it Donnie Not Wahlberg?
Yes.
Yeah. The mug's in the mail. It's in the mail. Respectfully, has the judge been living under the Plymouth Rock? Yeah. So the judge has to pretend that, everybody sitting there hasn't heard expert after expert say that there was no collision between the vehicle.
Right. Well, they're going to get somebody. They're going to get somebody who said there was. Right. That's been.
Well, yeah. Well, I got a guy. He uses blue paint. It's amazing.
Amazing, right?
What he can prove with the blue paint. I mean, get him on the phone now before somebody else gets him.
And Casey, by the way, wouldn't it be better to have the suit held in state or federal court? Well, federal court is not going to take a wrongful death suit unless it's attached to different
Civil Rights Act or something.
Civil Rights Act, or you have diversity of jurisdiction.
Yes.
And all. I don't think they're going to remove this whole thing. The federal court doesn't want to deal with this whole thing.
No, and the plaintiffs don't want that. They don't.
And the plaintiffs don't want that, and I don't think the defense wants that. They want to get their depositions in here, for maybe they want to get them in here and have a different suit or and all, whatever it would be. So I don't know. I think that the Alan Jackson, I think, is doing the strategy. He knows what he's doing. I'm not going to second guess him. So usually when you have a civil rights case, you do go to federal court, but this case is so different, and thank you, Miss Jessica NB, for supporting us. I really appreciate it. You know what you said there, and thank you very much for supporting us. So we have a lot more to talk about. We decided we would just give you the flavor today, and tomorrow, hopefully, we will go into this a little bit more because there's so much to unpack.
Something else. Let me just tease this before we head on out. I'm closing down the river. Lights are going down. I'm closing down the river. We've talked about this in the Donna Adelson trial. You may remember this. We got some body cam footage that has not been out there. And I just heard today, again, from Leon County, 2 more pieces of body cam video that I haven't even seen. So we're going to be sharing that later in the week. Just thought I'd throw it out there.
That'd be great. Yeah, I think we'll be sharing that on,
I think
Thursday, yeah. Thursday and Wednesday. You're going to be in Dedham for Aidan Carney's hearing,
right?
And hopefully Jimmy will come on. I don't know where we are with that. He promised. He said he owes me from.
It's a crapshoot with Jimmy,
but you never know, because he'll be at the hearing, and then that's at the hearings at 2, and then we're not going to do the show to 6, so we'll see. And then Friday we're working on a special guest, if we can. If not, we'll go from there. You let us know what you want to do. I know. And we are taping episodes having to deal with September being the National Addiction Month, to try to get a remedy for that. So we are taping some shorts on that. And they'll be up probably next week.
All right, then. Are we going to have Missy send us off into the wild blues?
Missy's going to send us off. I'm going to tell you before you go, hit subscribe, like, share, notify. Please hit subscribe, like, share, notify. We're out of jail in YouTube, and we're quickly approaching 29,000. Sui generis. Oh, these McAlberts are going to be
sui generis.
Sharon Reed deposition. Let me see. I have to start to get it to stop for me as I'm doing it. Carrying deposition to Turtle Boy's trial 2, shaking my head. More Adelson, yay! Free Turtle Boy, very good. Thank you, Sui Generous, for that. So hit subscribe, like, share, notify. You can't get one of those memberships that people so generously gifted unless you are a subscriber. And we want to get to 29,000 soon. Since
why not?
We're just rolling right along now.
And comments are welcome, good, bad, or otherwise. Bring it on.
Yeah, except when you accuse us of being fascist. We don't like that.
Well, that's a little extreme. That's a little extreme. If you want to criticize my hair, my shirt, that's free game. Okay, so that's it. I'm Michael Bryant. That's Linda Kenney Baden. We are Just to Serve TV, and please try to do the right thing.